So I'm going to be doing this presentation in English, and I would have, if I had started, acknowledged that much of this stream of research is coming out of a previous partnership grant that is still ongoing, led by Barb Nice, who is here and who is our discussant for this session. And we're going to make sure that she gets some time at the end because there are over 70 researchers over the last 7 years who have been working on these issues. So lots of your questions. Barb is the person to ask the question to. She's my friend. I didn't mean to do that. But in that case, I'm going to go fast. Because what I would like to do is to make sure that the regulatory framework within which these people are living their experiences is clear to everybody. It overlaps with what I said in the first part, but this time I'm really going to be focusing on mobility as such. ERGM, employment-related geographic mobility, it's our jargon. What are the challenges and challenges across the spectrum? I'll explain what the spectrum is in a minute. Focusing on accessibility to compensation, because commuting accidents and accidents in the home provided by the employer, for instance, create all sorts of legal issues that make it difficult to access timely compensation and timely care, and challenges specific to interprovincial mobility, and finally international migrants. But we have in this new grant, we have Janet and Jenna, who are here somewhere, and of course there they are, who are working on temporary foreign workers. And this is the legal underpinning that will also feed into what you've been doing. As you know well, and IAVCO, Marath, who is here as our partner, is a specialist in these issues as well. So I'm not going to repeat this slide. This is the definition of mobility that we've been using, but I draw your attention in particular. We're including temporary foreign workers within the concept of mobility, and we're including also Canadian workers working in another country, because mobility works both ways, internationally and nationally. It's what I said in the earlier presentation: short-term commutes, long commute within province or between provinces. And from a legal perspective, it's clear that if it's interprovincial, even if it's from Gatineau to Ottawa, you just multiply your legal problems. So that's the short version of this talk. We're also looking at double mobility. Desai Shan, who is here, has been working on mariners. There's another word for this. Maritime workers in the St. Lawrence Seaway, who are both living on the ship but also traveling to get to the ship. So that's another concept that from a legal perspective we have to look at, because there are all sorts of issues in that transportation to get to your ship. Then you're 6 months perhaps at sea. What does that mean in terms of return to work? So the short version, and the lawyers in the room will understand what I'm talking about, there are fuzzy concepts that are key in workers' compensation law. And one is commuting accidents. So technically you say, well, if I'm going to work and I came to work this morning and I was hit by a car crossing the street, that's not covered. Everybody agrees in all the provinces that's not covered. But if I'm a home care worker going between clients all day, it depends on which province you're in as to whether your injury between client 2 and client 3 is covered. Newfoundland, strangely, does not cover them. Everybody else seems to cover them. Most provinces, if you're going from home to client 1, you're not covered. And so this is complicated, fuzzy stuff. And when it's fuzzy, nobody's managing it, either from the employer perspective or from the prevention perspective. And when you're compensating after injury, then there's a whole debate. The farm workers, lots of tragic cases in Ontario where temporary foreign workers who were being bussed in and bussed out, their widows had to go to court to say this is not a work accident, so that they could actually sue the employer. And the contrary is also true. When nobody can be sued, the employers are in court to saying this isn't a work accident. So lots of case law on this mobility and whether it's covered or not. Fly in, fly out, same issues, drive in, drive out in remote regions, and then private roads. There's a 200-page report on this if you want more detail, but this is like the big overview. Jurisdictional issues, which workers' compensation board is going to be paying for this, and the rights are different. If you just think mental health problems, if you're working for the federal government and you're working in Gatineau, it's Quebec legislation which has been covering chronic stress for 20 years. If you're working for the same employer in Ontario, good luck. Basically, the short version of that is good luck. Who is the employer? If you've got temp agencies within different provinces who are providing, for instance, temp agency in Ontario providing temps to the federal government who are injured in Quebec. There are cases that take 5 years to figure out who's supposed to be paying this person. Everybody agrees that it's a work injury. And which exposures count. If you're working in construction, got carpal tunnel, you've worked in 3 provinces. There are some provinces in their case law that say we consider that anything done outside of our province, this is a Quebec case, is leisure time. So if you're working in Alberta, flying in, flying out, those exposures aren't calculated in the causation discussion. So there are serious issues that are raised by jurisdiction, and there's also interprovincial agreements on this, which I don't want to get into, but that you have to pay attention to. Nicola's research shows clearly, what if the worker wants to go home while healing? Those are the types of issues in Dana's work as well, that are coming up in the case law as well. The employers will say, well, you're no longer available for light work, and therefore I shouldn't be paying for the compensation because you're not available to take an assignation temporaire, a temporary assignment. And you see this particularly with international workers sometimes, as I'll get to in a minute, where employers try to get out of compensation at all by saying, well, they're no longer here, so I can't reduce my costs. And the employers who want to do medical exams, and they say, well, the man, and I think this is the man, he's not the real man, but when we're talking about temporary foreign workers and international migrants, these are 2 examples. We always think about the agricultural workers. We always think about agricultural workers, and they're very important, and a lot of the work that you have been doing is specifically for seasonal agricultural workers. But lots of the case law are people who are not at all agricultural workers. The case of the butcher is a French butcher who was working in Quebec. He cut his finger badly, couldn't work as a butcher, no light work. The board sent him home to France to heal. And then the employer, the mutuelle actually, which I won't get into the details of, the manager of the claim said, we'll save money if we decide that we want to give this guy light work, knowing that the guy had left. And the guy had left with the permission of the board. And the appeal tribunal said, the international jurisdictional agreements, I'm not aware of them. He left, he loses. So there are huge challenges for temporary foreign workers, both in terms of language, but in his case it wasn't language, and it wasn't that they didn't get it. It was that the system doesn't work well for these people. Obstacles attributable to vulnerability, concept for deportability, and there's a huge body of literature on this. If you think you might be deported, if you report an accident, you're not going to talk about your accident. This is Basok's work, but you've done an incredible work, and Sylvie Gravel and her team have also worked on this in Quebec. We have quite a rich group of people who have been working on this and these issues for years. Lack of information on rights, deadlines, and procedures has come out both in the literature and the interviews. But it's not just language, because people who speak perfect French are still, or perfect English, depending on where you are still having difficulties. Difficulties in accessing medical services in Canada, in temporary foreign workers in Quebec. There have been studies, and maybe in Ontario as well, where the doctors don't know they're covered by the medical care, or they don't know they're covered by workers' compensation. So they refuse to fill in the forms because they say, you're a temporary foreign worker, you don't get workers' compensation. So you find this out in an interview 9 months later when the person has 6 months to claim. Misinformed Canadian doctors, that's what I just mentioned. And other obstacles attributable to distance. If the worker leaves Canada, or even if the worker goes back to Newfoundland, as it came out in what Dana was saying, if it's not your guys and you have confidence in the doctors to whom you usually refer people as a board or as an employer, if it's a doctor that you don't know, what is the credibility of that doctor? Now, if the doctor is filling the form in Spanish and you're in either Quebec or Ontario, there's the increased likelihood that they're not going to understand what's written on that report, and that's going to create, at best, delays and maybe lead to ineligibility. Employers in Quebec, and I'm not going to get into the details of the compensation system in Quebec. Salut Richard, je viens de vous voir. The employers in Quebec are going to want to get second opinions. And we've seen cases in the case law where they mobilize the fact that they can't get a second opinion because they can't contest the treating physician's opinion if they don't have a second opinion, because in Quebec, the treating physician actually has weight, more weight than in Ontario. So they can't contest it unless they get a second opinion. They insist on saying that they can't get a second opinion from a doctor who's in France because they're not real doctors, because doctor is defined in the law as being part of Quebec's doctor system. The employers will lose on that eventually, but this creates contestation, and it goes through the system in a very sort of adversarial way, often with the worker not represented by anybody because he's back in France or in Guatemala or where he is. And we do not, contrary to other provinces, have the Office of the Worker Advisor or IAFGO. Okay. Alors, I've already explained this in French. I'm going to explain it again in English in more detail. And this is really the key issue, and it's difficult to understand, so you're going to have to pay attention, basically. In all workers' compensation systems in Canada, you get, as I said this morning, 90% of your net or 85% of your net, depending on your province. And then once you are better, in the sense you've achieved maximum medical recovery, the boards will evaluate what you can still earn. And in order to evaluate what you can still earn, they first determine suitable employment. And suitable employment, emploi convenable in French, there's a whole debate legally as to what's suitable, and we'll talk about that later on this afternoon. But say they decide that you can henceforth be a security guard. The salary generated by that job as a security guard, I'll take shoemaker because that is actually my case law here. The salary generated as a shoemaker, if you are working in Quebec and you've always lived in Quebec, is going to be the Quebec salary. The case in point, which is the first of the three that I'm going to discuss here, you've got three cases there. The first one, the Cirque du Soleil, an acrobat from Kazakhstan who is in the Cirque du Soleil, injured in the course of his employment, can no longer be an acrobat, is deemed to be capable of being a shoemaker in Quebec. But the problem is this guy is not going to be brought in to be a shoemaker in Quebec. He's going to go and work in Kazakhstan, maybe as a shoemaker. Shoemakers in Kazakhstan make $2,500 a year. They're deemed to make $25,000 in Quebec. So this issue of the disparity in the deeming process, depending on whether you take the salary of the local labor market where the person is injured, or the salary of the labor market where the worker is going to end up with their disability, is a key issue in all our studies looking at migration, immigration, and law. It's a key issue in interprovincial, and in Alberta, we know, we've done interviews, Alberta will look at Alberta salaries. So somebody working in a Tim Hortons in Alberta is making an awful lot more than if they're working at Tim Hortons in Newfoundland. And that deeming process reduces the residual benefits that you can receive. And the big struggle is to figure out which labor market are we going to try to return these people to, knowing that in the workers' compensation law, it's theoretical in the sense there is no obligation for any board to actually get you back to a real job. There's an obligation to give you benefits, and your obligation is to get yourself back to a real job. There's right to return to work in certain cases, but in this process, the deeming process, they find a virtual job and then they say, what can you do? So in terms of the earning capacity, it's really, really important to know which labor market you're looking at. It's radically different for the temporary foreign workers, but it's also significantly different for the interprovincial workers as well. And we've got, and Marath Yaknin from IAFGO has the one victory I've seen. Maybe there's more out there, and if anybody in the room can talk about this. It's the third case here, the Wisiat case, and the worker was from Jamaica? And to make a very long story short, the WSIB had said, we will look at how much you can earn in Ontario. He was an agricultural worker. And the court said, no, we're going to look at how much you can earn in Jamaica. And your residual disability pension is going to be in relation to what you earn in Jamaica. And this is key. It's very important. It does not, to my knowledge, and I'm looking at my Quebec partners, all the case law I've seen thus far uses not the foreign workers market, but the Quebec market. And it means that people end up with not very much in terms of pension, with huge disabilities living in their home countries. So these are things that we'll be continuing to be working at. But this is the process, and we have research assistants who are still working on this. Geographically mobile workforce. Sorry. Okay, this is my last slide. Heads up to Barb, who's going to come and do a little bit of discussion as soon as I finish. If a synthesis, because I tried, we've been doing this for over 7 years, and the new stuff is the return to work, but the old stuff is all the rest of it. And the overlapping between the precariously employed and the mobile workforce from a policy perspective is important. They're not, all the mobile workers are not necessarily precariously employed. But both precariously employed workers, like temp agency workers, and the mobile workforce are invisible to regulators. So that you start doing interviews with boards and that you have to really explain what you're talking about, the fly-in, fly-outs. I know that Marie-Ève Pelletier, who is here, has done research on fly-in, fly-outs in Quebec. And there was just no literature in terms of prevention and the working conditions as well. So the regulators don't see these people for prevention. They don't see them for compensation. They see the temporary foreign workers. They see them too much. So they're overly visible on certain areas. And then they're under visible on other areas, because once they're home, you don't see their suffering. They're not writing to the MPPs saying, this is really horrible and I haven't been able to feed my family. So all of these are the issues that overlap with precarious employment and mobility. We know about the challenges for occupational health and safety prevention. I'm not talking about that today, but as I say, we have a 200-page report. Challenges for return to work. To which labor market are we expecting out-of-province, out-of-country workers to return? That's the policy issue that we really need to be addressing. And early return to work provisions apply to this workforce with difficulty, and both Dana and Nicola very clearly demonstrated the types of difficulties that can come up. And also subcontractors, if they're in Alberta, are expected to be providing able-bodied workers in the same way that temp agency workers are expected to be providing able-bodied workers. And that creates new dynamics in relation to the mobility, because often the mobile workers are working for subcontractors as well. And a final example, I think this is my last slide, and then I'm going to call on Barb to complete. One of the things that we sort of touched on in both the presentations that we just saw, what you see in case law is that if you're working, for instance, in Alberta, and you have a rotation 2 weeks on, 2 weeks off, and the light work that is being offered to you is 2 hours a day, and that came out of Dana's interviews as well. Well, your 2 hours a day is not for 2 weeks and then you go home. It's 2 hours a day until you're better. And that might mean that you don't go home for months and months. So your rotation is completely interrupted. And those are the types of issues that we have to tease out in relation to understanding the data, which is important data that's coming out of the statistical and the data-driven research. And I'm stopping right now. I want to acknowledge not only our funding, which I did this morning, but On the Move. And I'm going to give the floor, before questions, I think, to Barb, and then we can all come up here for questions after. That's okay.